Mincov with Mincov Law Corporation. In this video, you will learn about the registration process in Canada. The process is quite long here. First, you file the trademark application. In this application, you need to describe the trademark and set out the products and services in association with which you are asking the trademark to be registered. You also need to state the basis of registration. The two most common bases of registration are use in Canada and proposed use. Not surprisingly, you would file your trademarks with the use in Canada basis if you are already using your trademark in Canada. And I discussed the meaning of the word use in trademark law in another video in this series, but to recap, a trademark is used in association with products if you place it on your products or their packaging. And your trademark is used in association with services if you use it while rendering or advertising those services. Alternatively, if you're only planning to start using your trademark, you would use the proposed use basis. The application is filed online together with a government fee of $250. Then, the application just sits in the Canadian Intellectual Property Office for about 6 months without anybody looking at it. When a trademark examiner finally looks at it in 6 months, in 70% of the cases, the examiner will find something they don't like in your application and will send you what is called an office action. It could be that you missed another trademark that may prevent registration of your trademark. It could be that your trademark is not registrable because the examiner considers it to be clearly descriptive or deceptively misdescriptive. Or it could be that the way you worded your statement of wares and services is not specific enough to meet the required standards. And it could be a dozen other reasons. If you receive an office action, you will have 6 months to respond with your reasons why the trademark should be registered or with amendments to make the examiner happy. If this satisfies the examiner, you're all set. Otherwise, you will receive another office action. You only get 2 kicks at the can. If after your second response, the examiner is still of the opinion that the trademark is not registrable, your application will be refused. If you convince the examiner that your trademark is registrable, your application will then be advertised in the Trademarks Journal. This opens a 2-month formal opposition period during which anyone can file a statement requesting that your trademark be denied. This is a rare occurrence, but it happens every now and then, especially if your trademark happens to be similar to a well-known trademark owned by a corporation with a substantial legal budget. If nobody contested your application, or if you were successful defending it during the opposition period, your application will be allowed. Now you will need to pay another government fee of $200. At this point, if you filed your application based on the use in Canada basis, you will get the certificate of registration of your trademark. If you file the application based on the proposed use basis, you will need to file a declaration of use, informing the Canadian Intellectual Property Office that you have started using your trademark. Once you file the declaration, you will get the certificate of registration. Again, this is a long process that normally takes anywhere between 18 and 24 months. If you are lucky enough not to receive an office action, you may be done in about a year. If you are unlucky to attract an opposition proceeding, the process may take as long as 3 to 5 years. You are not required to have a trademark agent assist you in filing of your trademark application. However, a trademark agent can save you a lot of time and frustration. If you look at the trademarks database, you will see thousands and thousands of trademarks that were abandoned after the applicant received the first office action. Unfortunately, this is what often happens when you file a trademark application yourself. The work of a good trademark agent does not stop with the filing of the application. It covers the whole process from start to finish and responding to those office actions is just an expected step in the process. In the previous video, I told you about 5 indicators that will tell you whether or not you should register your trademarks. And in the last video of this series, I will also tell you about the unique way that Mincov Law Corporation can assist you in registering your trademarks. In the next video, I will share with you a few tips and tricks that will help you in your brand strategy. Got any questions? You know what to do. Call me, email me, or go to our website at mincovlaw.com or newtrademark.ca. Thank you for watching. Talk to you soon.